All right. Good afternoon, everybody. My name is AJ Richmond. I'm a licensed criminal defense attorney here in the state of Georgia. Today, what I wanted to talk to you about was a new opinion coming out of the United States Supreme Court very soon called Rahimi. Rahimi is a case involving the Second Amendment and directly deals with domestic violence, family violence, convictions of misdemeanor convictions, convictions for felony conviction, and even temporary protective orders, or some people refer to them as restraining orders, family violence orders, bond orders that prohibit spouses from talking to one another. And in Georgia, there's a few different subsets of domestics. There's, of course, husband and wife. There's parents of the same children. There's step-parents and step-children. Sister, brother, siblings, brother, brother, sister, brother. Children versus parents. And, of course, now they've expanded to dating violence. So lots of ways to be wrapped up in the Second Amendment part of this. And for anybody who is looking at potential crimes of misdemeanor, felony, domestic violence, or that has a temporary protective order, at least in Georgia, but certainly all over the country, you need to. That's about to come down. We are going to get started here. Here we go. So the Second Amendment of the United States Constitution guarantees the right of people to keep and bear arms. The intersection between the constitutional right to do that along with being convicted of some kind of domestic violence has been going on in this country for quite some time. We're about to get to the actual statute that's an issue, but right now, if you've been convicted of a crime involving domestic violence, misdemeanor, felony, or have a temporary protective order or restraining order involving domestic violence, you are actually not legally allowed to possess firearms. It is a federal crime for you to possess firearms. So don't do it. The Second Amendment is something that maybe I don't think a lot of people actually read verbatim. And I think it's important to actually know what the Second Amendment actually says in the Constitution. So it's right here. It's this little paragraph. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. That's the key word here. Shall not be infringed. Now, let's break this up just a little bit. A well-regulated militia. What does that mean? Is that one person having his own militia, sort of like I think they said Kyle Rittenhouse was? Or is it a group of people, like it is on the movie The Patriot? Being necessary to the security of a free state. So are you defending yourself? Are you defending the state? And whether or not it's necessary to the security of you, meaning self-defense. The right of the people to keep and bear arms. Well, I think we can all agree that bearing arms are guns, right? Whether or not arms are guns as they are today. Remember, if we look up here, the Second Amendment to the United States was adopted in 1791. So the guns that are ARs didn't exist. Machine guns didn't exist. Rocket-propelled grenades, RPGs, didn't exist. Grenades may have existed back then, or some type of it, but the guns that we have, these automatic guns, these guns with 24 to 16 to 24 rounds, 9 to 16 to 24 rounds in the chamber, guns that can shoot 12 rounds in 2 seconds. Is that what this means? Well, luckily, that's not the issue of Rahimi. The issue of Rahimi is this part. shall not be infringed. Meaning, what statute can Congress create that limits your ability to possess firearms? So, the issues like we talked about are domestic violence versus firearms. And the central issue, and you'll see what I'm talking about in a few minutes as to who actually joined in on this, is whether is basically saying guns are unsafe. They're unsafe in the hands of people, and they're certainly unsafe in the hands of domestic violence abusers. But are they unsafe in people that have been accused of domestic violence in restraining orders by their significant other, but have never been arrested for a crime? Right? What if that restraining order was brought about as a result of a contentious divorce, where if you bring that forward, a judge may say, well, this person isn't a nice person because he used, domestic violence against his spouse, so we're not going to let him have the kids, we're not going to let him have his house, we're not going to let him have his money. Is that correct? Well, this Rahimi case goes into whether or not it is deadlier for domestic violence people to have guns versus people that aren't accused of domestic violence. And you'll see when you read the opinion, if you read the opinion, I hope you will, that in 1994, there was a statement made by Senator Wellstone: the presence of a firearm makes it 5 times more likely in a domestic violence incident where it will result in a homicide. So if that's 5 times more likely in 1994, I think we would all agree that today, since there's more guns than there were in 1994, there's certainly more domestic violence cases, whether or not there's convictions or not, since 1994, this would go up tremendously, probably 10 times. So, do we want domestic violence abusers to ever possess a firearm? And that's the court's question. So, the statute at issue here, this is what we're talking about. 18 U.S.C. 922 G8, which is a federal law that prohibits individuals who have been convicted of a misdemeanor crime involving domestic violence from possessing firearms. In Georgia, if you hit your wife, and I'm just using husband-wife as an example, it's easier to understand. If you hit your wife, and you get arrested, and you get convicted of hitting your wife, statute 18 U.S.C. 922 G8 prohibits you from ever possessing a firearm again. If you curse at your wife, and you're charged with disorderly conduct, and you're also charged with what's called family violence, which in Georgia is the Domestic Violence Act, you're prohibited from possessing firearms. Now, let's keep reading. This law applies to individuals who have been convicted of a misdemeanor crime of domestic violence, and here we go, as well as those who have been subject to a domestic violence restraining order. So, for those in Georgia, when we have what's called temporary protective orders or stalking orders, this law applies to you because you're subject to a domestic violence order. Now, there are some jurisdictions where when you get arrested for a crime, you're also given an order by the judge, what's called the domestic violence firearm order, which says you've been arrested for this, and therefore you're under the order of the court in addition to 18 U.S.C. 922. And therefore you can't possess a firearm, even though you're not guilty. Even though you haven't been to court. Even though the facts of the case haven't been brought forward. Right? Even if you win your jury trial during the time you've had that, which could be 2 years pending, even though you've had it pending, there's no apology, but for those 2 years you've lost your Second Amendment rights. And that, my friends, is where this whole thing is coming about. Where is that right? Is it right to take guns away? Let me back up. Is it right to prohibit guns from people that have been subject to a domestic violence restraining order? keep in mind, if we go back to the statute, it doesn't say anything about guns. About domestic violence. It doesn't say anything about family violence. It doesn't say anything about drugs. It doesn't say anything about felonies. What we see currently is that you can't possess a gun if you're a convicted felon. You can't possess a gun if you are a sex offender. You can't possess a gun if you've been charged and convicted for a misdemeanor crime of domestic violence. You can't possess a gun if you have a domestic violence order in place. And going back a second, a domestic violence temporary protective order or a restraining order, that's issued and granted by a judge. The burden of proof generally is what's called the preponderance of evidence or probable cause. So more likely than not, and all the way up to it's probable that you did this. It is, so think of it as between 30 and 50% that you did it. Beyond a reasonable doubt, which is what you need for convictions, felony and misdemeanor convictions, for crimes, things you get arrested for, is like 99.9% that you did it. But now we've lowered the standard to say, well, if a judge just says you did it for whatever reason, you now can't possess firearms. But nothing in the Second Amendment says that there's exceptions. Nothing in it says, well, it could be infringed if you commit these crimes. Certainly nothing in it says it can be infringed if you've committed a felony. Think about it. Let's say you're a convicted felon for wire fraud, for a Ponzi scheme, for tax fraud, for stealing a car, for taking $5,000 in merchandise from Best Buy, or taking a TV from Best Buy, putting it in your car and driving away. Okay, we're not excusing that behavior, but what we're saying is that felony has nothing to do with possessing guns. The wire fraud has nothing to do with possessing guns. The tax fraud has nothing to do with possessing guns. The Ponzi scheme has nothing to do with possessing guns. But because the statute says, well, if you're a felon, you can't possess guns. If you're a felon, you can't have your Second Amendment rights. We're now applying that to domestic violence. The question really is, where does it end? Where do the limitations end? Where do the exceptions end? Because under the amendment, all it says is if you're a well-regulated militia and you're using it for being necessary to the security of a free state, like self-defense, you can keep arms and nobody can infringe upon it. That's what it says. So where we're at is this Rahimi decision. It heard the oral arguments were in 2023, November 2023. And I put a little decision from the Fifth Circuit, but the Fifth Circuit agreed with Rahimi, and it said the statute is unconstitutional. It flies in the face of the Second Amendment. And now the case is in the United States Supreme Court. As of March 2nd, 2024, so 6 months or a few months after November, it's pending. And as of the date that I'm doing this recording is April 6th, it's still pending. But the issues that Rahimi has are going to be pretty big if the court rules on it. First, I think the court has to say something about the statute compared to the amendment. I think it needs to say, well, if we're going to exceed the verbiage of the amendment, we have to make it clear that where if the domestic violence, we can say a domestic violence user cannot or abuser cannot possess firearms, except he can possess firearms if he needs it for self-defense. So he can walk with it around town. He can keep it in his car. He can keep it in his house. He can go to the shooting range to practice. But he just can't shoot you with it, which itself is a crime. Because otherwise, they're going to erode part of whatever's remaining of the Second Amendment. They're going to erode it. That's what I think is going to have happen in Rahimi. Now, let me show you a little bit about how you can access this information. So first off, this is the Supreme Court of the United States website. And the cool thing about this is that this is a very hotly litigated case. So we'll see here it was filed. It's coming out of the Fifth Circuit. That was in March 2nd of 2023. And then, of course, within 2 weeks, they file what's called a writ of certiorari to the Supreme Court, and the Supreme Court eventually grants it. Now, let me show you all the people involved in this. So you see the words amicus. What this really means is these are what we call friends of the court. So these are other organizations that want to have a say, that want to tell the justices something about the case, whether or not they're in favor of the United States or whether or not they're in favor of Rahimi. Okay? So look at the people in favor of, well, it's going to be mixed, but the state of California, Texas Advocacy Project, gun violence and domestic violence prevention groups. Well, we know who they're arguing for. They're in favor of they're arguing for or in favor of the United States government. They want to keep the statute. New York County Lawyers Association, Illinois, Joshua Horwitz, Tarrant County Criminal District Attorney. They're in favor of the United States government. Mr. Rahimi. And then we have Patrick Charles in support of neither party filed. 97%, California Legislative Women's Caucus, City of New York, National... Sorry, my mouse is not moving. Second Amendment law scholars, educators and practitioners, Tarrant County Criminal District Attorney, New York Lawyers Association, professors of history, and on and on and on and on and on, senators, former state chief justices and chief judges, Global Action on Gun Violence. If you think that this decision, Americans Against Gun Violence, Domestic Violence Legal Empowerment, Center for Prosecutor Integrity, Public Defenders, the Cato Institute, National Association of Gun Rights, the Bronx Defenders, National Association of Criminal Defense Lawyers, Rifle and Pistol Association, and on, Second Amendment Foundation. If you think for a minute that this isn't going to be the biggest, most important case involving gun rights, in addition to domestic violence, you're out of your mind. You are out of your mind. This case is going to blow a former case called Heller, G-L-L-E-R, out of the D.C. Circuit, I believe, in the Supreme Court. This case is going to blow that out of the water. This case is either going to totally erode the Second Amendment, or it's going to totally erode any statute that infringes upon the Second Amendment. It's going to put it in the garbage. These are all the lawyers now involved. And you'll hear, when you listen, I'll show you how to do it, but when you listen to the oral argument, you'll hear these two individuals argue in front of the Supreme Court, and they do a heck of a job, both of them. But look at the rest of the lawyers. Huge law firms, big-time lawyers, lawyers from all over the country. On and on and on. We're still going. Crazy. Now, this is called oyez.org. This is a great website. I learned this in law school. You can listen to the oral arguments. You can see the facts of the case, and you can understand what the question is. Does this statute which prohibits the possession of firearms by persons subject to domestic violence restraining orders violate the Second Amendment. It is the cleanest issue. And the judges are either going to say there's 9 judges, so we need a majority, one way or the other. 5 justices are going to say, well, it does, or 5 are going to say, well, it doesn't. And then we're going to figure out what's left of the Second Amendment, or what's left of federal statutes that violate the Second Amendment. So all of this will be in. If you like all of this and like what I'm saying, please subscribe. If you have any questions, please leave those questions in the comment. Thank you for listening, and we'll see what happens when Rahimi gets decided. Take care.